Good morning to all of you. Let us continue the question paper of 2016. Right here, now we are going to question number 17. Question number 17 says, Z, an advocate, forged a stay order as if it is passed by the court. The court did not give the stay order. Our man, the lawyer, prepared the stay order. Right? And of course, he charged the fee from the client. Subsequently, the client found that the stay order is a forged document. See how bad it is. When he filed a complaint of professional misconduct before the Bar Council using its powers under Section 35, they conducted the inquiry and ultimately they deemed that it is a professional misconduct. Therefore, his name was removed from the list of advocates. Now, he challenged the removal as unconstitutional. Of course, he has got right. He can approach the Bar Council of India, then ultimately Supreme Court is the final arbiter. Here, he has approached the court. So please remember, the main point the issue in this case is giving forged stay orders. Did you hear? Yes, they happen. Please remember. Right? So, definitely, of course, even we don't expect that lawyers will resort to stoop down to such types of practice. Definitely, it is a clear case of professional misconduct. Right? Don't even you need not cite the rule also. There is no specific rule that the advocate should not give the forged orders like that, but it is a general point. That's why professional misconduct is not able to be defined. So there is a case law, Pratap Narayan versus YP Raheja, 1993, I believe. Yes. So Pratap Narayan, he filed a complaint before the Delhi Bar Council against YP Raheja. YP Raheja, who is he? This man is an advocate. So what the advocate was appearing on behalf of the so-called Pratap Narayan, and after long adjournments, on one day the advocate handed over him a stay order. Right? Actually, the court did not pass any stay order, and when this man went along with the stay order, it was found to be forged one. Ultimately, for giving the forged order, the man filed a complaint before the Bar Council of concerned state, then Bar Council of India, which the disciplinary committee of the Bar Council of India came to the conclusion that the respondent advocate himself handed over the forged order, which was not at all passed by the court. So definitely, what more is necessary? But here, you have to know the defense also. The respondent advocate pleaded that the forged stay order was handed over to the complainant by his clerk. So, vicarious liability, whether he is clerk or advocate, normally if the clerk gives, what do you think? Yes, you think that the advocate himself have given, is it not? So, please remember, the committee opined that if the clerk had done it, then it is the duty to inform the court that his clerk had done mischief and even he has forged the signature. Of course, it is clear that respondent himself handed over the forged stay order, which was not passed by the court. So, court took it very seriously. Disciplinary committee took it very seriously because it is nothing but fraud, is it not? The fraud played on the court by another advocate. Of course, not this man directly, whatever it is. So please remember, and moreover, the complainant, Mr. Pratap Narayan, said that the advocate said, nothing will happen, come on, you go, the stay order is in your hands, you can do whatever you like. So, basing on the assurance given by the advocate, he has gone to the police station, he requested for the police aid and all these things. So please remember, the committee held that the respondent was guilty of professional misconduct of a very serious nature. He forged the order of the court. So therefore, the no lesser than the punishment of removing him from the rolls is necessary, is essential. Yes, definitely, it is not against to his Article 19(1)(g) or his unconstitutional, all these things, they will not go. Right, last case. Question number 18. A client gave 10 vocals to an advocate and paid rupees 80,000 toward the court fee, and also he gave 10 cases. Maybe some banks like these people, for the defaulters, they will be attaching cases like this. He gave 10 vocals and he paid 80,000 toward the court fee and also lawyer's fee. But he filed only 5 suits and the decretal amount of 5 suits was misoperated by so he filed only 5 cases, he left the other 5 cases. Okay. Then in these 5 cases, when the decree came, then he took away the decree, he took away the money and he misappropriated the same. And stated that he informed the client that the cases were decided against him, against the client. So the client said, believing the advocate, he gave money, he gave wakalat, but this man has not filed for 50% of the cases and he took away the decretal amounts also. Then he filed a petition, the client, then it was held to be a professional misconduct and he was suspended from practice by 5 years. Now he is challenging the decision as unconstitutional. How can it be unconstitutional? So please remember. Number 1, Rule 11 says, whenever you take up a case, you must attend the court on all dates of the hearing. You must be able to take the case till the logical end. But you should not, even though you are appointed as an advocate under Order 3, Rule 4, it is your duty, please remember, to attend the courts. It is your duty to file the cases. It is your duty to submit the remarked OS suits also. But you cannot neglect in that issue. If you neglect, definitely it comes under professional misconduct. So please remember, so this is very clearly stated in so many cases. Rule 11 is the proper rule. Anyway, here there is one case law, I believe, 120 చూద్దాం ఒకసారి కేసులో ప్రతాప్ నారాయణ కన్నా డిఎస్ దలాల్ అనే కేసు ఉంటుంది, చూద్దాం ఒకసారి. ఉపేంద్ర భట్, డిఎస్ దలాల్ వర్సెస్ State Bank of India. So there is another case anyway. Allahabad Bank versus Girish Prasad Verma, right? 1975, I believe. 1983, I'm sorry. 1993. In this case, Allahabad Bank, they gave, this Girish Prasad Verma, they gave some cases. So more than 50 suits. So they have to, bank people, they have to file number of suits. But it is alleged that he did not file at least 50 suits, and even though he filed the suits, they were pending for payment of proper court fees, and 2 substances were dismissed for payment of court fees, lesser court fee. So రకరకాల ఉండాల్సినవి ఉన్నాయి. He did not file the cases properly, he did not attach the court fee and stamp value, court fees కట్టలేదు. So 52 cases they were not seeing the light of the day. So therefore they have withdrawn his services. They were actually handed over to other advocate. Then later they came to know that this same advocate, Girish Prasad Verma, he misappropriated the sum paid by him to the complainant for the purpose of court fee. So just like our 80,000, he has swallowed the money. So thus the advocate has misappropriated 1,36,144 rupees in total. So definitely he was guilty of not filing cases and also collecting the court fee from the bank and not filing cases. So definitely it is a professional misconduct and Bar Council of India suspended him. And they have referred in this case, the reliance was placed on Bar Council of Maharashtra versus M.E. Dabholkar, 1975. So normally the advocate, he has to do social function whenever he has taken the so-called కట్ట తీసుకున్నప్పుడు he has to file the case. He cannot shirk his responsibility. Limitation will be over, is it not? So another case, D.S. Dalal versus State Bank of India, 1993. So in this case, actually the State Bank of India gave some cases to our Dalal, right, against Delhi flooring mills, etc. in 1975. But Dalal told that records are missing from the High Court. Evidence shows that the High Court has given him back the records. So definitely it is a professional negligence. That means without filing the same or without complying with the remarks by the court, he has played mischief. So please remember, when you take wakalat, when you file wakalat under Order 3, Rule 4, it is your duty to attend the court on all possible dates of hearing. And I told you, if you are not able to attend the court, no problem. You can at least send your proxy, or you can at least inform the court that you are not able to come. But here the main point is that he did not at all file the cases. 50% of the cases he did not. He has taken the lawyer fee, but he did not. So So it is a clear case of professional misconduct on the part of the advocates. So to conclude, definitely the advocate should take up once he takes up the case under Rule 11, he has to take it to the logical end. Otherwise, it is called as professional misconduct. Right? So with this, we are completing question paper number 2016. Thank you very much.